Court for the District of Columbia, alleging in paragraph 48 of its complaint that the Executive Office of the President and others violated the First Amendment when it placed on the White House website the following message. Quote, "There is information about health insurance reform out there, spanning from control of personal finances to the end of life care. These rumors often travel just below the surface via chain emails or through casual conversation. Since we can't keep track of all of them here at the White House, we're asking for your help. If you get an email or see something on the web about health insurance reform that seems fishy, send it to flag@whitehouse.gov, close quote. The complaint asserts that the defendant's collection and maintenance of information on speech protected by the First Amendment chills the right of free speech. Will they prevail? Who knows? I'll be interested in seeing how that case progresses. But don't tell the White House that. I make no comment about whether any health care issues are fishy. I'm just addressing First Amendment issues. First Amendment cases are everywhere in our judiciary. You hear about them in the news, and many of them you don't. There are 56 cases from the Supreme Courts of the various states on the U.S. First Amendment decided so far this calendar year. 56 out of various state Supreme Courts. 196 cases also come from the various circuit courts of appeals at the federal level. 4 are pending at the United States Supreme Court to be decided this term. One of those Supreme Court cases was just heard in oral argument, Citizens United versus Federal Election Commission. Citizens, a nonprofit corporation, made a movie about presidential candidate Hillary Clinton. Make no mistake, this movie was political and for the purpose of demonstrating why people should not vote for her. For example, in one of the advertisements, they showed an image of Senator Clinton and stated, "First, a kind word about Hillary Clinton." Then it shows Ann Coulter saying, "She looks good in a pantsuit." Then the announcer states, "Now, a movie about everything else." The lawsuit involves Citizens United's attempt to avoid the disclosure requirements of federal law, the Bipartisan Campaign Reform Act of 2002. That act requires various disclosures, the names and addresses of people who contributed over $1,000 and other type disclosures. But the real issue in the case is whether or not corporations and unions will be permitted to make direct political contributions, which arguably would cause much more political speech and perhaps movies as this one and other speech. The Wall Street Journal, in an article this week, predicts that Citizens United will prevail and makes the point that even if the film had been aired on cable, it would have had fewer viewers than amateur political videos for its presidential candidates posted on YouTube. It was founded in 2005. Blogging on the internet, Twitter, posting YouTube videos, puts the power of free speech into the hands of people through technology in ways never previously available. Individuals may blog on newspaper websites and have instant, statewide access to an audience without any cost. So we have the means to conduct free speech as never before, and I believe the incentive is there as well. It's fair to say that we're in extreme conditions as a nation. We're experiencing the most difficult financial challenges since the Great Depression, including huge numbers of job losses, businesses destroyed, and foreclosed homes. We have wars in Iraq and Afghanistan. We face substantial issues that may affect our daily lives and health care, and we live in a politically divided country. My impression is that those divisions seem to be very deep and are becoming more difficult to reach across. I don't know about you, but my sense of the country is that we're in a full-time political campaign. So the combination of the availability of ways to speak and the conditions of the country that cause people to want to speak out, and with great passion about what they think and what they believe, have together created a greenhouse effect for new situations and events that require First Amendment attention. That's why I believe the First Amendment is the most important constitutional issue facing our country at this time. On August the 14th, a little over a month ago, Yale University Press published a statement that it was publishing a book called The Cartoons That Shook the World This November. The press stated that it declined to reproduce the newspaper page that included cartoons of the Prophet Muhammad that the author proposed to include. The original publication in 2005 of the cartoons led to a series of violent incidents and repeated violent acts that have followed republication as recently as June 2008, when a car bomb exploded outside the Danish embassy in Pakistan, killing 8 people and injuring 30. The next day, Al-Qaeda claimed responsibility for the bombing and called it revenge for the insulting drawings. Around the world, more than 200 lives have been lost and hundreds more injured after republishing of the cartoons. At the time of the initial crisis of the cartoons in 2005-06, the New York Times, Washington Post, and Boston Globe declined to print them, as did every major newspaper in the United Kingdom. Yale University consulted domestic and international experts on behalf of the press, counterterrorism officials, former ambassadors, the top Muslim official at the United Nations, and senior scholars in Islamic studies were consulted. All counseled against publishing the cartoons. The highest-ranking Muslim at the United Nations stated, "You can count on violence if any illustration of the Prophet is published. It will cause riots, I predict, from Indonesia to Nigeria." The concluding paragraph of the Yale press release states, "Yale and Yale University Press are deeply committed to freedom of speech and expression, so the issues raised here were difficult. The university has no speech code, and the response to hate speech on campus has always been the assertion that the appropriate response to hate speech is not suppression, but more speech, leading to a full airing of views. The press would never have reached the decision it did on the grounds that some might be offended by portrayals of the Prophet Muhammad. Indeed, Yale University Press has printed books in the past that included images of the Prophet. The decision rested solely on the experts' assessments that there existed a substantial likelihood of violence that might take the lives of innocent victims." End of the statement. The university received some criticism for not publishing, including among its alumni. Was there a First Amendment violation by Yale in refusing to publish the controversial cartoon? No. Remember, the First Amendment only forbids governmental restrictions on free speech and the free press. Yale is a private university, not a public institution. So the First Amendment was not implicated. Yale simply decided not to invoke its First Amendment right, its choice to do so. We all remain silent and not exercise our right to speak. That's not to be confused with our Fifth Amendment right to remain silent when charged with a crime. But let's change the facts a little bit for sake of discussion. Judges like to do that. What if Yale wanted to publish, but the government, out of concern for violence, instructed the university to not publish? What if the president had said, "You know what, it's my job to protect the citizens of the United States of America. Their protection comes first. And I'm going to protect them, so you cannot publish this," and enters an executive order by the president. Or have administrative rules by the Department of Education or Homeland Security or other administrative agencies. Or a law passed by Congress. Or get an injunction issued by a court. Would those actions by a government pass legal